Yes, my viewers and subscribers, welcome to another episode of Jamaica Politics Uncovered. New subscribers, welcome, and returning subscribers, welcome back. Guys, I am bringing you the second day of the Vybez Kartel Privy Council appeal case, and I have been saying that I don't know what the outcome is going to be. But after day 2, guys, and hearing the arguments made, me feel like right now, I may be wrong, but me feel like them are go throw out this thing here. Yes, because I just one thing the Privy Council business about, that the case continued with this particular juror that tried to corrupt the thing, you understand? So, me going to make you hear the arguments, and then, you tell me in the comment if you don't agree with me, because the person that is arguing for the prosecution, for Paula Llewellyn them, he might make him argument, but the people them we might talk to, every time them come back with for them argument, them might talk like, say, boy, the juror should have been dismissed, and the judge had the opportunity and the responsibility to do that.
There's a different point that Lord Briggs makes, which is about the introduction of the rest of the jury, but it's just this one point. Supposing the judge is entirely satisfied that 10 jurors can perform their duty properly, I'm sure they're able to do it, but he knows that one is very unlikely to do so. Supposing that is the position, the question is, as a matter of law, must he discharge the jury? That is the question. And if the answer to that is yes, he must, then I accept I'm in difficulties. If the answer is no, he doesn't have to, if the prosecution is content to take the risk that this one juror is just going to vote against the prosecution, come what may, in my submission, he's entitled to do that.
I think the answer that would normally be given is you must discharge that juror.
If of course, I agree with that. In normal circumstances.
So if we assume that the legal position is you must discharge that juror, what is then your submission?
Well, in my submission, if you absolutely must, in all circumstances, even in a case such as this, where you've got right to the end of the trial, you can have a 10-1 verdict, and so forth. If you must, then, my lords, I accept. Then what has happened is that the verdict that was given by 10 people who were entitled to be on the board of panel, and one person who wasn't. And then the consequence of that would be, I suppose, that you do not have a quorate verdict.
The implication of your submission seems to be that in a criminal trial, and you could hardly have a more serious trial than this, where you have 5 people accused of murder, clearly there's a public interest in a true verdict being returned. The implication of what you're saying seems to be that the judge really has no responsibility in that regard. He's entitled, if the prosecution are willing to run the risk of the jury being nobbled by the corrupt member of the jury, that's a matter for them, and he can go along with that.
My lords, he has to be satisfied that the other 10 won't be nobbled, or it's very unlikely they'll be nobbled. I'd accept that. But if his thinking is, and I submit it was likely to have been this, I've got one bad juror here, I've got good reason to suppose the other 10 will behave properly. That means there will be, the jury will be quorate at 11. In my submission, he is entitled, he is not bound to say, I've got to stop the trial now. He has a power to allow the trial to go ahead. That is, and my lords, I accept that is the kernel of my submission. It has to be one which he exercises not entirely unreasonably in all the circumstances of the case. That is why I'm making the submissions I have been.
If it were the case that the same rules applied in Jamaica as apply in England and Wales, that is, you could have had a jury of 10, what would you then say?
My Lord, I think I'd be bound to accept that the judge would have said, let's go down to 10. He probably would, in those circumstances, have said, balancing...
So the problem that you're faced is a system that doesn't allow a jury of 10.
That's exactly the problem. The whole problem.
An unfair trial, it might be put against you, is allowed because the rules don't allow a jury to go around to 10. Is that right?
No. I'm not saying that. I'm far from saying that. As long as the trial is fair, overall. I haven't come to my point about the fairness of the trial, but as long as the judge is satisfied that a fair verdict can be returned, even though one juror appears to be bent on assisting the defence, the judge can say that of the lesser of two evils is that the trial goes ahead, the administration of justice is served by the trial going ahead, and there is no common law rule that requires me to stop the trial.
The corrupt juror might be critical, his vote might be critical to whether there was a majority or not.
It might be. But in those circumstances, that is a risk that the prosecution takes.
Well, that's the point. You see, that's the point I'm jibbing at, really.
Yes.
The idea that responsibility for the administration of justice in the public interest is the responsibility of the prosecutor and can effectively be waived, if you like, by the prosecutor, rather than being the responsibility of the court.
Yes, I do accept that, but my lord, it is still the responsibility of the court. If the court is satisfied...
But we see the problem. If you're presiding in a criminal trial where a majority verdict can be returned, and you know that one of the members of the jury, or you have good reason to suspect that one of the members of the jury may be corrupt, for all you know, the way he votes in the jury room could be critical to the verdict that's returned, and could result in a wrongful acquittal, for example.
My lord, again, I come back to my point. The judge is entitled to weigh up all the different evils. I mean, the real problem is that the judge was caught between two evil solutions.
Yes, I've got the greatest sympathy for the judge. And I mean, in this country, we would think twice about rerunning a 67-day trial. But in a country like Jamaica, the expense involved in this, apart from anything else, is enormous.
But, my lord, my submission is this: as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably, rationally in making these decisions, and as long as they are satisfied that overall there can be, not necessarily that there will be, but there can be a fair verdict, if there can be, then in my submission the lesser of two evils is to go ahead and get that fair verdict, rather than simply say trial off, no verdict, which in real life may well mean no trial whatsoever. And that is why I say one must look. It's not just a matter of sympathy for the judge, it's what is the responsible, forgive my putting it this way, the responsible response to this very, very difficult situation. Which is the lesser of two evils? And my submission is the lesser is to go ahead in the hope that there can be a fair verdict. You may well land up with an unfair acquittal. That is one risk you take. But it is better to take the chance of getting a fair verdict than to abandon that altogether.
That fair verdict would be reached in circumstances where the allegedly corrupt juror would not only have a vote, but he'd have the opportunity to influence the other members of the jury.
Well, he might still seek to influence the other members of the jury, but he wouldn't. Sorry?
In deliberation.
In deliberation. He can still say what he likes in deliberation. He can still draw attention to a good point, let us say. That can still happen. He's not prevented from doing so. He may well be able to persuade one of the other jurors, not by offering money.
Well, by offering money.
No.
But he may.
No, he may be able to persuade one of the other jurors in deliberation. Look, forget about my bribe. These people are innocent because of point X. He's still entitled to do that.
Well, he's entitled to do that, but he's not entitled to persuade them by offering them bribes.
Certainly
That is an ongoing risk.
That is, my lady, I accept that is an ongoing risk.
Yeah.
That must be right, is a risk. He will try again.
Yeah.
I mean, you might think it's a bit unlikely if the matter's been reported to the judge, actually, but there's a possible risk. Let us say there's a possible risk. My lady, even in those circumstances, if that is a risk which the prosecution is prepared to take in order to achieve a verdict, that is the lesser of two evils, and if both the judge and the prosecution think that is a proper way of proceeding, they can. That is my fundamental point. And one of the problems with jury trials is one is trying to create a system of perfection, in one sense. Of course this is not perfect. No one would begin to say it's perfect. But is it, in fact, the pragmatic way forward, which did, in the event, secure a fair verdict? That is not.
But the defendant's counsel didn't accede to this way of proceeding. That they continued to raise Well, on the face of it, it looks as if they were objecting.
They did. There's no doubt about that. But they were objecting for different. They weren't objecting on the quorum point, but they were objecting because of the way it's put, I think, by one of them is the overcompensation point. I'm concerned about it, and that's a fair point.
Yeah.
I'm not saying it's a bad point, but in my submission, it's not a conclusive point. The judge is entitled to say, well, I'm still prepared to put this matter to the jury because of the various points I'm going to come to later, because the strength of the case, I've been assured that I will give another direction. I have already given directions about not being persuaded by extraneous matters. The judge, in my submission, and this is, in a sense, the heart of the case, was he bound to stop it? My answer is no, he was not bound to stop it, for the reasons I've given. And I do submit, I take my Lord's point about the Court of Appeal's judgment, but I do submit this is important to bear in mind what the Court of Appeal had to say about this matter. They have familiarity with how juries work, how the system works.
Yeah, guys, so on the ear what go on. You see, maybe somebody can explain this to me, but I have served on a jury here in the United States before. And how it works is during jury selection, they are going to pick more jurors than they need, which means that if somebody on the jury either sick or dead, them can reach out to those them tell to be on standby so them can come in and replace that juror and the case can continue. For the life of me, I cannot understand why in Jamaica, with this particular case, that juror who tried to corrupt the rest was not dismissed immediately and they brought in a juror that was on standby. I mean, I understand that it's hard to just pick up the whole case and dash it out because one juror tried corrupt the thing. You understand, guys? Me get that. But at least they should have had the opportunity and should have taken it to dismiss this person immediately and replace that person. Right? So you can have the same amount of people for going to the deliberation room. But we will see how it goes. I feel like they are going to let this thing here get overturned. And in my view, some of you may not agree with me. Some of you may agree. But clearly, that juror who tried to corrupt the rest was doing so on behalf of Kartel. When get the 500,000 from all them things they should have looked into, if it hasn't already been so. But leave in the comments and let me know what you think, guys. Today is the end of it, so in the near future, in the coming days maybe, we will hear what the Privy Council decides. Keep it locked here to Jamaica Politics Uncovered. Have yourselves a nice day.